Okay, here I am perusing YouTube I was looking for a judge. Says here about this one judge, mistreated employees act beyond her authority. Yeah, that's deprivation of rights. She's actually violating the code of judicial conduct. You know, the judge is supposed to be courteous, gracious. Okay. We'll get to that one later. Oakland judge defends her conduct. There's no defense in violating the code of judicial conduct. And this is the judge I was looking for. I seen it, and judge who called herself a new racist vacates position after 7 investigations.
That's the sound of an American oil company hard at work. Want to be a part of it? Listen up.
Hello, my name.
The 7 investigators first broke in September of 2024. 7 investigator Heather Catallo is here with what she has learned.
This has been a long process. You'll recall we revealed recordings of Judge Kathleen Ryan making some shocking statements. Judge Ryan has essentially been on paid leave for 15 months and once described herself in those recordings as untouchable. The Judicial Tenure Commission has been investigating this for more than a year, but they did not take action against her. Her lawyers confirming to me late today that she is retiring, and the vacancy for her position has already been posted by the governor's office for potential candidates to apply for an appointment to the bench.
I can honestly say that. Okay, I'm not systemically racist, I'm a new racist.
The 7 investigators were the first to reveal the recordings that Oakland County officials say prompted Judge Kathleen Ryan's removal from her docket in August of 2024.
Black. I'm so off with this Black Lives Matter, hashtag Me Too, all this. Oh my God, like, you.
On Wednesday, a judicial vacancy was posted on the State Bar website saying the former Oakland County Chief Probate Pro Tem Judge was vacating her position on the bench.
Kathleen A. Ryan presiding. Good morning. You may be seated.
Ryan was a probate judge for 13 years until the Oakland County Probate Court Administrator filed a complaint against her, alleging Ryan had been harassing him, calling him after hours for years, and making racist and other inappropriate comments.
I've never met anybody that enjoys hurting people and brags about it the way she does, or intimidating people, scaring people.
Hutton says his complaint was not acted on for months, so he then sent the recordings of his calls with Judge Ryan to state and county officials.
I just want to make it right, and I want the people in Oakland County that come to court to get a fair shake, to have their day in court, to have an unbiased trier of facts.
If you're black from any other country, you're doing way better. If you're an American black person, then you're a lazy piece of.
Judge Ryan has been paid for the last 15 months while she was out of the courthouse, and taxpayers have been footing the bill for visiting judges to handle her docket. Now her lawyers say she is retiring and leaving the bench. Judicial Tenure Commission investigations are not public unless they reach the point of the JTC filing formal charges. Again, that did not happen in this case, so the results of that will not be made public. Now, meanwhile, I did speak with one of Judge Ryan's colleagues, Judge Daniel A. O'Brien. He said Judge Ryan was a good judge, and he expressed frustration that the court was left with visiting judges for so long while the JTC investigated, saying that really left a lot of cases not having continuity. So at least there's some resolution. She's retiring.
At least, and I'm sure a lot of people who have been in front of her are going back in their memories and going, wow.
Did I get a fair shake? Yeah. All right.
Okay, legally, she violated the oath of office, to uphold the Constitution, see to it that everybody gets a fair trial. Considering the fact that she was racist, she should have recused herself from anybody that didn't live up to her standards. And then again, the people that did, she would show favoritism, so either way, she shouldn't have been on the bench, period, and all her decisions should be reviewed considering the fact of her blatant prejudice and biases. Not just against, she said, not just against, but she didn't like the Me Too movement. You know, I've been called a feminist because I've always thought the Me Too movement meant something a long time ago. And that's when I was a kid during the Jane movement. And, you know, I mean, if a woman has to do the same work as a man, you know, she should get the same pay, you know, if she lives up to the same responsibilities. A lot of people say, oh, well, you're just a feminist. No, it's an equal rights thing, you know, because there's, speaking as a minority, places I've worked where I didn't get equal pay. You know, I had to work harder, longer, do more. Just always more was expected of me, and I got less pay. So yeah, let's get back to the judge. She violated the oath of office. She violated the oath of public service. Deprivation of rights because nobody received a fair trial. Anybody can claim deprivation of rights, considering the fact her attitude. She's blatantly, honestly, open racist, you know, and the judicial whatever, you know, review board, whatever it's called, the JTC over there. I mean, them closing it off and not letting the public know the outcome, not in the public interest, in the interest of the bar, clearly in the interest of the bar, thus making it under the color of law, so illegal. Open those doors and let the people in. The public is guaranteed public trials. It's not just a guarantee for the defendant, the plaintiff, but the public in general, so they have knowledge of what's going on in court, regardless of who it is. You have no right to do that. Oakland County judge running for prosecutor after Tina Talbert case, whoever Tina Talbert is. Okay, so as long as the prosecutor, whoever's running for prosecutor, lives up to the rules of professional conduct, Rule 3.8, special responsibility of the prosecutor, you know, which seems to be null and void, which in most cases people I try to help, you know. So not abiding by that is nothing other than malicious prosecution. Okay, and for any judge to allow that, that's judicial misconduct. You know, that's deprivation of rights. Two or more people knowingly and willingly not reporting misconduct, any violations of the rules of professional conduct and the code or the code of judicial conduct is misconduct, and you cannot violate the rules without violating the codes. You know, it's a symbiotic thing. You know, you damage one, you damage the other. So let's get into. I wanted to talk about probate court because I'm going to help this kid with probate court, and here. And nobody's talking to him. The lawyer says they only want to talk to a certain person in the family, and that person's out of state, and they said if they want to talk to a lawyer, they'll send some underling, and that'll cost them $100 an hour. So I mentioned it was violating the rules of professional conduct. And then I mentioned the judge allowing this to happen is violating the code of judicial conduct because the judge isn't reporting the misconduct by your attorney. So he said, what? And I says, yeah, your attorney isn't abiding by the rules of professional conduct. I told you about that. And he says, yeah, but that was in a different case, different kind of court. And I says, no, it doesn't matter. No matter what courtroom you go into, no matter what kind of case it is, the rules and the codes are universal. And so I started going over the rules with him, and he was saying that he didn't do that. I says, I know, and the judge knows that too. They're supposed to be making sure nobody violates the rules or the codes. Nobody commits misconduct. And if they do, it's their job. Okay, there's a lot of things that don't happen in court. Reasonable doubt, that doesn't happen. Disclosure law, that's always violated. That's why so many people have a hard time in courts. Everybody's supposed to guarantee disclosure. That's called discovery and facts of court. So that means, anything and everything that's used against you, you're allowed to view this evidence. And that doesn't happen, no matter what court of law you're in. Color of law by definition. So that's what they're doing. They're operating under the color of law because nobody's abiding by the oath. Nobody's living up to the oath. You don't have effective assistance of counsel, and nobody's reporting that ineffective assistance of counsel. Thus, nobody reporting it leads to a conspiracy against rights under the color of law. I talked to you about giving unlawful orders. It's unforgivable. It's punishable. Penalties for violating, living under the color of law. Okay, this is what I told him, what he would have to say. Because this is basically what happened. The judge failed to report my counsel. This is my amended complaint, something I wrote for somebody. They needed something to put on their complaint for conspiracy against rights under the color of law in under 500 words. So this is what I gave them. Conspiracy against rights under the color of law. They didn't have to put that title in there because that's what they're filing under. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct and my counsel for ineffective assistance of counsel and themselves for misconduct. My counsel failed to report the judge for judicial misconduct and the opposing party for misconduct and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. Failure to report misconduct is misconduct, as is a failure to enforce one's constitutional duties as prescribed in the rules and the codes. The lack of the requirements from the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. Deprivation of rights in its entirety. Everybody in that courtroom can be charged for deprivation of rights as well as a conspiracy against rights under the color of law. It clearly shows the judge and attorneys in my case committed a conspiracy against rights under the color of law, which prohibits the willful deprivation of rights. Privileges or immunities under the color of law are prohibited. Prohibits conspiracy to injure, oppress, threaten, or intimidate any person in free exercise of their enjoyment or any right or privilege secured by the Constitution or the laws of the United States. I trust you will live up to the oath. I'm using the rules of professional conduct to blast them. I trust you will live up to the oath and show competence, diligence, I forgot, in expediting litigation as I have meritorious claims and contentions, so I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violations and every penalty will be imposed. In the public interest, as trustees, this is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. It's supposed to say in the interest of justice, dismissal with prejudice. An interest of justice, dismissal with prejudice is legally required, as is inciting the RICO Act. Okay. So that's pretty much seals the deal in any courtroom. If you say that in court, but this is for a complaint to the DOJ and the FBI and every other civil rights agency out there. But I told them, you're going to have to know what you're talking about. Legal obligation, treat someone as innocent until proven guilty, presumption of innocence. And you know that doesn't happen. The RICO Act, the definition of conspiracy against rights under the color of law.
Often I've had people...
Legal obligations to act in the public interest. That's why I use that term, the public interest, so much, because it's a legal obligation. It's a law.
You can kick.
Let's see, it should be down here. Yeah, okay, so I read to you about it says communications, ethical violation, every penalty will be imposed in the public interest as trustees. This is how to maintain the public trust. Failure to do so would add to this conspiracy against rights under the color of law. So when you tell the judge, when you want to tell the judge about doing their job, because this kid's got to go to probate court, and they're not going to let him talk. All right, I just say talk to your lawyer, and the lawyer don't want to talk to him. Says if he wants to talk to him, that's $100 an hour out of what he's going to get in the probate court. Okay, so we're going to go to Canon 2. A judge shall perform the duties of judicial office impartially, competently, and diligently. So this has been in the making for about 10 years, which is a lack of diligence, which is highly incompetent. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in the proceedings or that person's lawyer the right to be heard according to law. Your lawyer didn't communicate this to you, so he should. It's legally obligated to. And ensuring the right to be heard, Your Honor. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in proceeding the right to be heard. A judge shall perform their duties of judicial office impartially, competent, because if they don't let you talk, they're violating everything that follows. So it's impossible to violate one canon without violating the other. Okay, so Canon 2, judge shall perform his duties impartially, competently, and diligently. Report Rule 2.15, reporting or responding to judicial and lawyer misconduct. A judge knowing that another judge has committed a violation of this code that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge or in other respects shall inform the Illinois Judicial Inquiry Board. A judge that knows a lawyer has committed a violation of the rules of professional conduct of 2010 that raises a substantial question regarding a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the Illinois Attorney Registration and Disciplinary Commission. Okay, so that's what you're telling the judge. You know, just tell him, you know, I know, we all know that my lawyer violated the rules of professional conduct, which is ineffective assistance of counsel. Right here it says you're supposed to report this lawyer. And to let him proceed in this case, to even let this proceedings to continue without first, you know, informing all the appropriate authorities for all the violations and the rules and the codes. Okay, so a judge knowingly inform the attorney registration. A judge knowing another judge has committed violation of codes does not raise a substantial question. Well, if they violate one rule or one code, they violate multiple codes. You know, they diminish the integrity of the court to the fullest. A judge shall accord to every person who has a legal interest in proceeding or that the person's lawyer be right to be heard the law canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety in all the judge's activities. Rule 1.1, compliance with the law. A judge shall comply with the law, including the code. The codes are laws. Rule 1.2, promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Rule 1.3, avoiding misuse of the prestige of judicial office. A judge shall not misuse the prestige of judicial office to advance the personal or economic interests of a judge or others that allows others to do so. Canon 2, a judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2.1, giving precedence to the duties of judicial office. The duties of judicial office as prescribed by law shall take precedence over all the judge's personal and extrajudicial activities. So you see that guy that was saying the judge was calling him for years, after hours, you know, at work, harassing him. That's against the law. The judge knew it. He took an oath to do all this and is not doing it. Rule 2.2, impartiality and fairness. The judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Rule 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. A judge shall not, in the performance of judicial duties by words or manifest bias or prejudice, or engage in harassment, including not limited to bias, prejudice, harassment based upon race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation, and shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. Proceedings before the court shall be conducted without manifesting bias or prejudice or engaging in harassment based upon attributes including but not limited to race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, or political affiliation by or against lawyers, parties, witnesses, or others. The restrictions of paragraph B and C do not preclude judges or lawyers from making legitimate references to the listed factors or similar factors when they are relevant to an issue in the proceeding. E. A judge shall not retaliate against those who report violations of Rule 2.3. A violation of the Supreme Court of Illinois' non-discrimination anti-harassment policy is a violation of this rule. Rule 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, or financial or other interests or relationships to influence the judge's judicial conduct or judgment. A judge shall not convey or permit others to convey the impression that any person or organization is positioned to influence the judge. Rule 2.5, competence, diligence, and cooperation. A judge shall perform judicial duty and administrative duties competently and diligently. A judge shall cooperate with other judges and court officials in the administration of court business. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in the proceeding or that person's lawyer right to be heard by law. A judge may encourage parties in the proceedings and their lawyer to settle matters in dispute, but a judge shall not act in a manner that coerces any party. Rule 2.7, responsibility to decide. A judge shall hear and decide matters assigned to the judge except when disqualification required by Rule 2.11 or other law. Comments. Although there are times when disqualification is necessary, protect the rights of litigants, to preserve public confidence, independence, integrity, and impartiality, judiciary, a judge must be available to decide matters that come before the courts. Unwarranted disqualification may be public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect, the fulfillment of judicial duties, and proper concern for the judges may be imposed upon judges. Colleagues require the judge not use this qualification to avoid cases that prevent difficult, controversial, or unpopular issues. Rule 2.8, decorum, demeanor, and communication with jurors. A judge shall require order and decorum in proceedings before the court. A judge shall be patient, dignified, courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others whom a judge deals with in official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's direction and control. That's what that guy was complaining about. And that judge is retiring. A judge shall not commend or criticize jurors for their verdict other than in a court order or opinion in the proceeding. Rule 2.9, ex parte communications. A judge shall not incite, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending matter, except as follows. Disqualification. A judge shall disqualify himself or herself in any proceeding in which the judge impartiality might reasonably be questioned, including but not limited to following circumstances. Rule 2.12, supervisor duties. A judge shall require court staff, court officials, and others subject to the judge's discretion and control to act in a manner consistent with the judge's obligation under this code. A judge with supervisory authority for performance of other judges takes reasonable measures to ensure that judges properly discharge their judicial responsibilities, including the prompt disposition of matters before them. Rule 2.16, cooperation with disciplinary authorities. A judge shall cooperate and be candid and honest with judicial and lawyer disciplinary agencies. A judge shall not retaliate directly or indirectly against a person known or suspected to have assisted or cooperated with investigation of a judge or lawyer. Rule 3.1, extrajudicial activities in general. A judge may engage in extrajudicial activities except prohibited by law or the code. However, when engaging in extrajudicial activities, a judge shall not participate in activities appear to be reasonably personal, undermine the judge's independence, integrity, and impartiality, engage in conduct that would appear to be reasonable person to be coercive, or make use of premises, staff, stationary equipment, or other resources except for incidental use. Supreme Court rules, Article 7, Illinois Rules of Professional Conduct. Okay, so basically I told you everything. If the judge doesn't report misconduct, or if the judge is clearly guilty of judicial misconduct. Okay, so I told him so this is what he's going to have to, the right to be heard, and failure to let you be heard is violating all these other codes, okay? And this is in probate court. So the judge is supposed to, and he's going to have to, like he did before, cite the violations of the rules of professional conduct. Now, this is the preamble. Okay, a lawyer as a member of the legal profession is representation of clients, an officer of the legal system, and public citizen having special responsibilities of the quality of justice. As a representative of clients, a lawyer shall perform various functions. As an advisor, a lawyer provides a client with informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts a client's position, which rarely happens, under the rules of an advisory system. A negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. This is where I always battle with the PD's officer failure there, big time failure there. In addition to these representational functions, a lawyer may serve as a third-party neutral, a non-representational role helping the parties to resolve a dispute or a matter. I've often told people to seek a third-party arbitrator, when getting a divorce. A lawyer who commits fraud in the conduct of business is subject to discipline or for engaging in conduct involving dishonesty, fraud, deceit, misrepresentation. See Rule 8.4. That's misconduct in all professional functions. So that's basically they violate the codes, the rules. That's fraud, deceit, misrepresentation. In the conduct of business. Okay, all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer shall maintain communication with the client concerning the representation. A lawyer should keep in confidence information relating to the representation of a client, except so as far disclosure is required or permitted by the rules of professional conduct or other law. A lawyer's conduct should conform to the requirement of law, both in professional service to clients and in lawyer's business and personal affairs. A lawyer should use the law as procedure only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. That means abiding by the rules of professional conduct. While it's a lawyer's duty when necessary to challenge the rectitude of official action, it's also a lawyer's duty to uphold the legal process, due process thing. As a public citizen, a lawyer shall seek improvement of the law, access to the legal system, the administration of justice, and quality of justice rendered by the legal profession. As a member of the learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge to reform the law, and work to strengthen legal education. In addition, a lawyer should further the public's understanding of and confidence in the rule of law. And the justice system, because legal institutions, in addition, a lawyer should further the public's understanding of the confidence in the rule of law and the justice system, because a legal institution is a constitutional democracy, depend on popular participation and support to maintain their authority. It is also the responsibility of those licensed as officers of the court to use their training, experience, and skills to provide services in the public interest for which compensation may not be available. It is the responsibility of those who manage law firms to create an environment that is hospitable to rendering of reasonable amount of uncompensated service by lawyers participating in that firm, service in that public interest that may take forms. Those include, but are not limited to, pro bono representations of persons unable to pay for legal services. I shouldn't need organized bars efforts as law reform. An individual lawyer's efforts in these areas is evidence of the lawyer's good character and fitness to practice law, and the efforts of a bar is essential to the bar's maintenance of profession to help monitor the quality of extent of these activities and encourage and increase the delivery of the legal system of persons limited means. Illinois Court Rule 756 requires disclosure with each lawyer's annual registration with the Attorney Registration and Disciplinary Commission, an approximate amount of his or his pro bono legal services, and the approximate amount of qualified monetary contributions. The absence from rules of a counterpart to the ABI model rules regarding pro bono service should not be interpreted as limiting the responsibilities of lawyers to render uncompensated services in the public interest. Rather, rationale is responsibility. It is not appropriate for disciplinary rules because it's not possible to articulate the appropriate disciplinary standing regarding pro bono public services. 7. Many lawyers' professional responsibilities are prescribed in the rules of professional conduct as well as substantial and procedural law. However, a lawyer is also guided by personal conscience and probation of professional peers. A lawyer should strive to obtain the highest level of skill to improve the law and legal profession and to exemplify the legal profession ideals of public service. A lawyer's responsibilities as a representative of clients, an officer of the legal system, and a public citizen are usually harmonious. Thus, when an opposing party is well represented, a lawyer can be a zealous advocate on behalf of a client and, at the same time, assume that justice is being done. So also, a lawyer can be sure that preserving a client's confidence ordinarily serves the public interest because the people are more likely to seek legal advice and thereby heed their legal obligations when they know their communications will be private. In the nature of law practice, however, conflicting responsibilities are encountered. Virtually difficult ethical problems arise from conflict between a lawyer's responsibility to the client's legal system and a lawyer's own interest in remaining as an ethical person while earning a satisfactory living. The rules of professional conduct often prescribed terms resolving such conflicts. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues must resolve through an exercise of sensitive professional and moral judgment guided by basic principles underlying these rules. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interests. Remember, lawyer's obligation. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law while maintaining professional courtesy and civil attitude towards all persons involved in the legal system. The legal profession is largely self-governing, although other professions also have been granted powers of self-government. The legal profession is unique in respects because of the close relationship between the profession and the process of the government of law enforcement. This connection is manifested in the fact that ultimately all authority over the legal profession is vested largely in the courts. To the extent that the lawyers meet the obligations of their professional calling, the occasion for government regulation is obviated. The regulation that helps maintain the legal profession is independence from government domination. Independent legal profession is important to forces preserving government under law. For the abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for rights to practice. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that regulations are conceived in the public interest and not in furtherance, parochial, or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. Lawyers should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and public interest which it serves. Lawyers play a vital role in the preservation of society. The fulfillment of these roles requires an understanding by lawyers of their relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. 14. The rules of professional conduct are rules of reason. They should be interpreted in reference with the purpose of legal representation in the law itself. Some of these rules are imperatives cast in the terms of shall or shall not. These define proper conduct for purposes of professional discipline. Others generally cast in terms may are permissive and define areas under the rules which a lawyer has discretion to exercise professional judgment. No disciplinary action may be taken when the lawyer chooses not to act or acts within the bounds of such discretion. Other rules define the nature of the relationship between the lawyers and others. The rules are thus partly obligatory and disciplinary and partly constitutive and descriptive, and that they define the lawyer's professional role. Many of comments use terms, should comments, and the preamble and scope do not add obligation to the rules, but provide guidance for participating in the compliance with the rules. The rule's purpose as a larger legal concept, shaping a lawyer's role. The context includes court rules and statutes relating to matters of licensure, laws defining specific obligations of lawyers, and substantive and procedural law in general. The comments are sometimes used to alert lawyers to the responsibilities under such other laws. 16. Compliance with the rules, as with the law in an open society, depends primarily upon understanding the voluntary compliance. Secondly, upon reinforcement by peer and public opinion are finally, when necessary, upon enforcement, thus disciplinary procedures. The rules do not, however, exhaust the moral and ethical considerations that should inform a lawyer. For no withholding, human activity can be completely defined by legal rules. The rules simply provide a framework for ethical practice of law. Furthermore, the purpose of determining a lawyer's authority and responsibilities, principles, substantial law external to these rules determine whether a client-lawyer relationship exists. Most of these duties following the client-lawyer relationship attach other and after the client. As requested by a lawyer to render legal services, a lawyer has agreed to do so, but there are some duties which that of confidentiality under Rule .6 that attend the lawyers agree to consider with a client-lawyer relationship shall be established. See Rule 1.8, whether a client-lawyer relationship exists. Under various provisions, including constitutional, statutory, and common law, the responsibilities of government lawyers may include authority concerning legal matters that ordinarily repose in a private client-lawyer relationship. For example, a lawyer for a government agency may have authority on behalf of the government to decide upon settlement or whether to appeal for an advised judgment. Such as authority in various respects generally vested in the Authority General of the states and state government and their federal government counterparts, and such may be true of other government law officers. Also, lawyers under the supervision of these officers may be authorized to represent several government agencies and intergovernment. Failure to comply with an obligation or prohibition imposed by a rule is basis for invoking disciplinary process. The rule presupposes a disciplinary assessment of a lawyer's conduct will be made on the basis of the facts and circumstances as they existed in time of the conduct in question, and recognition of the fact the lawyer often has to act upon certain incomplete evidence and the situation. Moreover, the rules presuppose that whether or not discipline should be imposed for a violation depend on the circumstances such as willingness and seriousness of a violation, extenuating factors, and whether there have been previous violations. Violation of a rule, says of a rule, not multiple rules. Violation of a rule should not itself give rise to a cause of action against the lawyer, nor should it create any presumption in such a case that legal duty has been breached. In addition, violation of a rule does not necessarily warrant any non-disciplinary remedy, such as disqualification of a lawyer in pending litigation. The rules are designed to provide guidance to lawyers and provide structure for regulating conduct through disciplinary agencies. These are not designed to be a basis for civil liability. Furthermore, the purpose of the rules can be subverted when they are invoked by opposing parties as procedural weapons. The fact that rule is just basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of disciplinary authority does not imply that an antagonist or collateral proceeding or transition has a standing to seek enforcement. Nonetheless, since the rules do establish standards of conduct by lawyers, a lawyer's violation of rule may be evidence of a breach of the applicable standard product. Okay, so there we go. The comment applying to each explaining illustrates the meaning and procedure of the rule. The preamble and this note on the scope provide general orientation and are instructive and not directive. The comments are intended as guides to interpretation of the text of each rule. Okay, Illinois Rules of Professional Conduct. The kid was talking about Rule 1.5, communication, the lack of. Every time they try to talk to him, they call him or somebody in the family. It's probate court. They blow him off, or they tell him, hey, you can talk to somebody in our litigation team, but that's going to cost you $100 an hour. So, well, there we go. Scope of representation and allocation of authority between client and lawyer. They aren't discussing any of that with him. Diligence. Was there diligence in any communication? Communication is mandatory. I right now just put the rules, but if you go and look up the rules of professional conduct, and then it'll give you a complete definition as what required diligence, communication, fees. Those fees are unnecessary because nobody's explaining to them about Rule 3.2, expediting litigation or the lack of. This has been going on 10 years plus, you know. So he finds, the lack of diligence in expediting litigation not competent, incompetent. That's Rule point 1. Okay, so he was saying that the lawyer mentioned something about other parties or whatever, so I told him he should read fairness to the opposing party. And then I discussed partiality and decorum towards the tribunal, but your lawyer's not going to do that, neither is the opposing party, whoever that is, and the judge doesn't care. The judge knows there is no impartiality and decorum in the tribunal. Okay, truthful, innocent statements to others are, your lawyer's not doing that with you, okay? Like I said, fairness to the opposing party and counsel, one must be diligent in expediting litigation. That would be competent, that would be diligent. So there's no excuse for the opposing party to withhold anything or take any time. That should be done first, fast, and foremost once the suit is filed, or it's probate court, Dealings with an unrepresented person. I spoke to people about that when it comes to Rule 3.8, special responsibilities of the prosecutor, because a lot of times people will get arrested and the prosecutor will come to see you at the police station and offer you a deal, and no, that's illegal. Legally they can't talk to you. The police can't even talk to you without a lawyer present. But they will. They'll beat the hell out of you. Don't tell them what they want to hear. Okay, violating any of these rules is misconduct, which is Rule 8.4. And reporting misconduct is mandatory according to Rule 3.8. Reporting professional misconduct and transfer to disability and active status. Okay, but reporting professional misconduct, that's mandatory. Failure to report misconduct is misconduct. So the judge failed to report your lawyer for misconduct, which is judicial misconduct. Okay, because we went over that in the beginning about reporting professional misconduct. Any lawyer is violating the rule of professional conduct. It's the judge's duty to report that lawyer to the Attorney Registration Disciplinary Commission, and since the judge didn't do that, now it's the judge's responsibility to report themselves to the Judicial Inquiry Board for failure to report the lawyer's ineffective assistance of counsel and their lawyer's failure to report them for judicial misconduct, and for themselves for failure to report judicial misconduct up until that point. Okay. And for the judge not to hear them out and not cite everybody for misconduct, lawyers involved, himself, at that point right there, and that's contempt of court. The judge is in contempt of court in the very court they preside over, which is illegal. You know that. So you're going to have to cite the judge for contempt of court. And the lawyers, hey, everybody's breaking the law here. What's going on, guys? What's going on? That's contempt of court, Your Honor. Supposed to cite people for, violating contempt of court. Okay. Let's go. All right, look at competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. So it's not to say they aren't competent, but they did not act in a competent manner. So they violated Rule 1.1. Okay. Scope of representation and allocation. Okay, because sometimes they'll tell you they can do things they can't. Like telling you they got pulled over a judge, which is, they can't even say that. Ask the judge. A lawyer shall abide by a client's decision concerning objectives of the representation as required by Rule 1.4. Shall consult with the client as to the means by which they are to be pursued. A lawyer shall take such action on behalf of the client that is implied authorization to carry out the representation. A lawyer shall abide by the client's decision whether to settle the matter. In a criminal case, a lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial or whether the client shall testify. A lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of a client's political or economic, social or moral views or activities. A lawyer shall limit the scope of representation if the limitation is reasonably under the circumstance the client gives informed consent. Now remember, in order to give informed consent, you need reasonable knowledge to make an informed decision to give that informed consent. You not knowing anything I talk over with you doesn't give you that reasonable knowledge to make an informed decision, to give that informed consent. You're just starting to be able to get the idea what informed consent is, and it's a legal obligation. A lawyer shall not counsel a client to engage or assist a client in conduct a lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with the client and may consult a client to assist the client and make good faith effort to determine the validity. Okay, diligent communications, fees. Them not do anything makes any fee illegal. Okay, but you should go over the fees. Confidentiality of information, that's quite often broken. Known to some as ex parte communications. All lawyers shall reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is a legally authorized order to carry out the representation, or the disclosure is permitted. A lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. To prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime or fraud, to prevent, mitigate, or recidify substantial injury. Okay, so you're gonna have to get on that. Okay, confident. See, so a lawyer may tell you that those words like diligence may not think what you think it means, and you're just going to open up the rules and tell me, well, it says right here, and then they'll tell you, see, well, legally you saying anything else is violating the letter of the law, which there's penalties for that, and that leads to disinformation, and there's penalties for that. And then look up the penalties for that. They'll shut that all up. Clients with diminished capacity, well, in order to give informed consent, you need reasonable knowledge to make an informed decision to give that informed consent. And the only way you'll be able to give that informed consent if that reasonable knowledge is the legal knowledge equal to that of those that you oppose in the court, which is every attorney and judge in that courtroom, even the one you hire in your defense, if they aren't going over this as I am with you, so that's who you're opposing. That's deprivation of rights. So you can consider yourself a client with a diminished capacity because up till now, you actually had no knowledge of what was going on in that court, you know. Safekeeping property, that's what I was talking to the kid about. Because he's going to probate court, all right? And this happens to a lot of people, and people don't understand this. This happens in conservative, guardianship, probate, you know, nobody's doing this. A lawyer shall hold property of clients or third persons that is in the lawyer's possession in connection with representation separate from the lawyer's own property. Funds shall be kept in a separate account, maintenance in the state where the lawyer's office is situated or elsewhere with the consent of the client or third person. Other property shall be identified and as such appropriately safeguarded. Complete records of such account, funds, or other property shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of the representation. A lawyer may deposit the lawyer's own funds in a client's account for the sole purpose of paying bank service charges on that account, but only in an amount necessary for that purpose. A lawyer shall deposit into a client's trust account legal fees and expenses that have been paid in advance to be withdrawn by the lawyer only as fees and are earned or expenses incurred. Upon receiving funds of the property or other property in which the client or third person has an interest, a lawyer shall promptly notify the client or a third person, except as stated in this rule or otherwise permitted by law or agreement with the client. A lawyer shall promptly deliver to that client or third person any funds or other properties the client or third person is entitled to receive, and upon request by the client or third person shall promptly render a full accounting regarding such property. The kid was complaining about that. They don't know what's going on, period. When in the course of representation, a lawyer's possession of property in which two or more persons, one or whom may be a lawyer, claim interest, the property shall be kept separate by the lawyer until the dispute resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. Okay, so seriously, people, come on. If you're dealing with probate, guardianship, or you know somebody's dealing with guardianship, because that's usually what old folks are, even kids. I mean, come on, client with a diminished capacity. Anybody can claim that, client, because you don't have a law degree. You don't know the law. Sale of law practice, duties to a prospective client, meritorious claims and contentions. This rarely happens. Somebody will just go in there and point the finger, and next thing you know, you're in guardianship, you're in probate court, they're taking away your kids just because somebody made an accusation. You know, the presumption of innocence is totally gone. You know, somebody makes a Karen call, presumption of guilt is always prominent. A lawyer shall not bring or defend proceeding or assert or convert an issue therein unless there is a basis in law and fact for doing so, and that is not frivolous. It includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in proceedings that could result in incarceration may nonetheless so defend the proceeding as to the require that every element of case established. So if you can't prove it, it shouldn't be there. All right. Expediting litigation. Lawyers shall make reasonable efforts to expedite litigation consistent with the interests of the client. Candor towards the tribunal. A lawyer shall not knowingly make a false statement or fact or law to tribunal or fail to correct false statements of material fact or law previously made to the tribunal by the lawyer. Fail to disclose to the tribunal legal authority and controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Offer evidence the lawyer knows to be false. A lawyer's client or witness called by a lawyer has offered material evidence that the lawyer comes to know is falsified. The lawyer shall take reasonable remedies to measure, including the necessary disclosure to the tribunal. A lawyer may refuse to offer evidence other than testimony to the defendant in a criminal matter that a lawyer reasonably believes is false. A lawyer who represents a client in adjudicated proceedings who knows that a person intends to is engaging as or engaged criminal fraudulent conduct related to the proceedings shall take reasonable remedial measures, including, if necessary, disclose to the tribunal the duties stated in paragraph and continue to consultation of proceedings and apply even if compliance requires disclosure of information otherwise protected by rule points 1.6. In ex parte proceedings, the lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision. Trial publicity. Lawyers, special responsibilities of the prosecutor. I pushed this, I mean, and it's not happening. There should be like do public service announcements. Somebody. Prosecutor in a case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause, meaning there's no evidence whatsoever. Somebody made a Karen call, and that's why I'm here. I was walking to the store, and okay, refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. And they will, and the public defender will tell you, hey, just take the plea deal. And you want to take the plea deal, so you wind up sitting in jail. And they spent months trying to get you to take a plea deal, and the public defender, well, if you don't take the state's attorney, they're going to throw more charges at you. And the state's attorney, you should have took that gift I was offering in the first place. Now I'm going to come at you hard. And they won't even have a case. There won't even be probable cause. But your lawyer won't bring up that. They won't even ask for a probable cause hearing. That rarely happens. And they'll usually exceed, your right to a fair trial, limitations on that. State of Illinois, if you're out on bond 120 days, if you're locked up 90 days, and if you don't go to trial within that time, the case gets tossed out. Not to seek from an unrepresented accused waiver of important pretrial rights, such as the right to a preliminary hearing. Make timely disclosure to the defense of all evidence, information known. The prosecutor tends to negate all guilt of the accused or mitigates the offense, and coercion with sentencing, disclosure to the defense that the tribunal, all privilege, mitigating information known to the prosecutor, except when prosecutor is relieved of this responsibility by a protective order of the tribunal. Okay, so let's get down here. G. When the prosecutor knows of new, credible, or material evidence creating a reasonable likelihood that convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court or authority, and if the conviction was tamed in the prosecutor's jurisdiction, to promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of offense the defendant did not commit when the prosecutor knows of clear and convincing evidence establishing the defendant. In a case, prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy that conviction, exonerate you. And I've been trying, but always had to go it alone. I had some scary shit. They yell at me, chase me out of there. We don't work for you, we work for the government. I really need like a big group of people to go with me and my exculpatory evidence down to the Cook County State's Attorney's Office. Truthful statements to others. Of course, when representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person or fail to disclose material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client unless disclosure is prohibited. Respect the rights of third persons. Responsibilities of partners, man. They're supposed to make sure whoever's working under them is supposed to be doing all this shit. Responsibility of subordinate lawyers. They'll say, hey, well, they gave me the orders, but, you know, giving unlawful orders is illegal, as well as taking them. There's no, I was only taking orders as a defense. Unauthorized practice. So if anybody tries to tell you what those laws mean, kid, you know, that's why I say you need a copy of the rules of professional conduct and a code of judicial conduct. And you have to practice what you're going to say, kid, all right? And I was telling him, too, this is a conspiracy against rights under the color of law. He could file with the DOJ, FBI, and other civil rights divisions, and they have to sue and prosecute on his behalf. And him and his family could come out way better off after that than they would just from what Granny left behind. Okay. Okay, there we go, folks. I forgot where I even started. But either way, you go to probate court, don't forget to take the rules and the codes. Just tell the judge, you know, do your job. break out the codes and the rules. That's their legal obligations. That's the law in the court of law. They have to abide by those laws just like as anybody else when you're out on the street. The laws as well as out there. Okay, people. Nothing but peace and love for you. May your Creator always be with you and rain many blessings. I wish you a long life and good health. And I'd wish you luck in your court endeavors, but you don't need luck. What you need is the law. And you need to take it with you. Plenty of people yelled at me, hey, if they know that's their job, why ain't they doing it? You're talking to the wrong person. You need to talk to the judge and the lawyers in court and bring the rules and the codes. If you're just starting out in that procedure, you bring the rules and the codes to make sure everybody plays by the book so you don't get snookered, hornswoggled, bamboozled. I sound like Denzel when he was playing Malcolm X, huh? I mean, not loud, but just okay. Just if you want accountability, if you don't want to, lose what you got, let's start from the beginning, okay? How everything is supposed to start from the very beginning. That's why anybody and everybody that's had a case in any court of law got a case against the people that drag you through the court of law because nobody abides by the rules and the codes, and thus creating that conspiracy against rights under the color of law. Historically, nobody can prove that anybody's done all of this. So you're so used to the way they work the system, you accepted it. You accepted them operating under the color of law. Look that up. There's penalties for that, operating under the color of law. Let's see. Operating under the color of law refers to action performed by government officials using appearance of authority and legal position. Even the action itself is abuse of power or entirely unlawful. The concept is crucial in civil rights laws. It establishes the necessary link between individuals' action and the government for a violation to be actionable under federal statutes. Key aspect, an action under the color of law if the official is purporting or pretending to act in the performance of their official duties, regardless of whether or not they are acting within the bounds of their lawful authority. The perceived authority is derived from the government position, local, state, and federal. Responsible parties. This applies to a wide range of public officials, including police officers, prison guards, judges, mayors, and others who are granted authority by law purpose. The legal concept is primarily used to prevent government officials from abusing their power and infringing on constitutional rights of individuals, which is now, as the constitutional crisis. Violations, actions that constitute a deprivation of rights under the color of law are federal crimes, include offenses such as excessive force, false arrest, sexual assault, theft, and intentional fabrication of evidence. Legal concept. The concept is primarily found in two key federal statutes. 18 U.S.C. 242, the criminal statute makes it a crime for a person acting under the color of law to willfully deprive another person of any right or privilege protected by the U.S. Constitution and law. 42 U.S.C. 1983, the civil statute allows individuals whose civil rights have been violated by statute local officials acting under the color of law to file a lawsuit for redress. The FBI is the lead federal agency for investigating criminal color of law violations. Penalties for a conviction vary based on the severity of the offense, ranging from fines and imprisonment to life in prison or death penalty if death or serious bodily injury results. And like I said, it's easy to get your lawyer for deprivation of rights. And them, dragging through the courts the way they have. They were acting under the color of law. They weren't doing anything they were supposed to be doing, so they were acting under the color of law. Opposing party, your own lawyer, the judge. And see, they do mention that you have a right to sue. They're acting under the color of law. Even those immigrants being picked up by ICE. I mean, that's deprivation of rights. Constitution guarantees anybody charged with a crime due process. Not just citizens. Anybody charged with a crime in the United States or its territories are guaranteed due process. Deprivation of rights, conspiracy of rights, conspiracy against rights under the color of law. Color of law violations, federal civil rights claims, federal civil rights statutes, color of law. See, I'm just showing you a lot of laws you could look up, legal websites, addressing police misconduct, law enforcement, color of law, what it means, and its impact on civil laws. Okay, there's 45 pages of this. I'll leave that up to you. I always found the law fascinating, interesting. Especially all these laws that nobody is abiding by or yet alone enforcing. Violating every one of them. Acting under the color of law. Operating under the color of law. And you don't have a chance unless you have a legal degree to compete with them. That's why I created legal reform. To give you a helping hand. I'm a peace and love for you, my friends. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Good night.